Good morning, ladies and gentlemen. May I have your attention, please? And I now like to declare the East Asia Conference of Competition Law and Policy officially begin. And I now have the pleasure to invite Mr. Eiji Chatani, Chairperson of the Japan Fair Trade Commission, to come on stage and give his opening remarks. Thank you.
Good morning, everyone. My name is Eiji Chatani, the chair of the Japan Fair Trade Commission. It is my great pleasure to open the 17th East Asia Conference on Competition Policy and Law in Tokyo. First of all, I'd like to express my sincere gratitude to Dean Brojo Negoro and the officials of the Asian Development Bank Institute, Advisor Elhan Kailar and the officials of the Asian Development Bank, and Professor Chen, Professor Wakui, and other ASCOLA Asia members for their contribution as co-hosts. Since 2004, the East Asia Conference on Competition Law and Policy has served as a forum of presentation and Q&A sessions among participants from academia, the legal field, and competition authorities. Its main object is to build a common understanding of the importance of competition law and policy in the East Asia region. This event is open to the public, and we have a large audience here today. As this conference is being live streamed and can be viewed from anywhere in the world, I hope that this event will contribute to a better understanding of the importance of competition law and policy, in other words, advocacy activities throughout the East Asia region. Today, we have 3 sessions. The topic of session 1 is KFTC and JFTC on digital. Japan and Korea have both built strong track records in enforcing laws in the digital sector. Let me briefly highlight key differences. In Korea, the main competitors include not only US big tech, but also major homegrown companies like Naver and Kakao in areas such as e-commerce, app stores, and search engines. Korea also has a distinctive enforcement approach. In addition to imposing fines, companies suspected of violations can propose their own remedies. When those remedies aim to restore harm or improve business practices, a coexistence fund may be used to support that process. Japan, on the other hand, has been focusing on broad fact-finding surveys across many fields. For example, ride-hailing apps and news content. And beyond enforcement of Anti-Monopoly Act, Japan also introduced the Mobile Software Companies Competition Act, MSCA, last December, which was developed through a cross-government effort. We are confident that the MSCA will be implemented effectively. With that background in mind, I hope you enjoy the discussions today, which will be led by a distinguished researcher and full of valuable insights. Session 2 is Keynote Speech. The speech title is Building Together, Adapting Smart Digital Competition Policy for Asia's Diverse Economies. As you know, competition policy in the Asia-Pacific region varies widely across countries and economies, reflecting differences in economic conditions and the timing of introduction of competition laws. There is also significant diversity in the current stage of development. Our speaker today is Elhan Kailar, advisor from the ADB. She is a leading expert on digital transformation, DX, and market competition. For many years, She has worked to develop knowledge and policy solutions addressing the challenges faced across the Asia-Pacific region, and she was made outstanding achievements in this field. Considering the diversity of this region, I expect that today's speech will offer valuable insights into what effective competition policy in this region should look like going forward. Session 3 focuses on Indonesia. The title is Indonesian Competition Law Landscape. Since introducing its competition law in the year of 2000, Indonesia has achieved significant results in law enforcement, particularly in the digital sector. One notable example was in January last year, 2025, when the KPPU imposed a fine of more than $12 million on Google for requiring app developers to use the Google Play billing system. Indonesia has also developed flexible, locally tailored systems, such as its partnership supervision system aimed at supporting SMEs. At the same time, there remain certain challenges. For instance, to my knowledge, the KPPU has faced limits on its enforcement capabilities under the current legal framework. In this session, we look forward to a discussion led by renowned Ascola Asia scholar exploring Indonesia's diverse initiatives and possibilities that lie ahead. Thanks to Ascola Asia's cooperation, today's program will be enriched with more academic insights than ever. I hope today's discussions will be more fruitful and help all of you take away many valuable insights. Thank you very much for your kind attention.
ありがとうございました。Thank you very much. 茶谷委員長、ありがとうございました。Next, we would like to have our co-chair, Professor Thomas Chen, University of Hong Kong. He's the co-chair of Ascola Asia, or Academic Society for Competition Law Asian Chapter.
Distinguished guests, colleagues, ladies and gentlemen, welcome to the 17th East Asia Conference on Competition Law and Policy. It's a great pleasure for me to welcome you to this unique event co-hosted by the Japan Fair Trade Commission, the Asian Development Bank, and Academic Society of Competition Law Asian Regional Chapter. And some of you may not be familiar with what we usually call ASCOLA, the Academic Society for Competition Law. And Professor Masako Wakui of Kyoto University and myself are the co-heads of this regional chapter for ASCOLA, which is a global academic organization of competition law scholars and counting more than 600 members. And we are very honored to have the opportunity to co-organize this event with the JFTC and the ADB. And so we gather at a time of enormous challenges, and I'm sure all of you are well aware of them. Digitalization and the popularization of AI create unprecedented business opportunities, but also unprecedented opportunities for competition abuses and exploitation of consumers, most notably in the form of algorithmic collusion and exclusion, which is an issue very close to my heart. Sustainability and green transition also presents very thorny issues on how we balance between competition and sustainability, an issue which I think many of us would agree is perhaps even greater than and more important than competition itself, and this is quite a statement to make in a room of competition lawyers. And finally, rising geopolitical tensions have thrust into the limelight an issue that has long been discussed about, but perhaps not on everyone's top of their minds, which is agency independence and industrial policy. And events in the last few years have shown us that agency independence cannot be taken for granted even in established jurisdictions. And So these changes test the boundaries of existing legal framework and enforcement tools, and raise fundamental questions about how to preserve competitive markets while promoting innovation, investments, and resilience. And it is conferences like this that allow us to confront these questions together rather than in isolation. So over the coming sessions today, the 3 sessions we have today, I hope we engage in frank and open dialogues and learn from the experiences of other jurisdictions, our fellow jurisdictions in the Asia-Pacific region, and also informed by insights from rigorous academic research. And let me close by expressing my sincere appreciation to our co-organizers, and especially to the JFTC again for giving ASCOLA the opportunity to co-organize this event in the city of Tokyo, one of my favorite cities in the world, as evidenced by more than 20 trips over the years. And I wish you all a stimulating discussion, new partnerships, and a conference that inspires concrete steps towards more competitive markets across the region. Thank you very much.
Thank you, Thomas. Thank you. Okay, then let's begin session 1. Session 1 is KFTC and JFTC on digital, and which is moderated by Yosef Choi, Professor Yosef Choi. Yosef, direct to come.
Good morning. My name is Yosef Choi, and I'm a professor of law at Hankuk University of Foreign Studies. As a moderator, it is my great honor and privilege to participate in the 17th East Asia Conference on Competition Law and Policy. I'm deeply grateful for the opportunity to contribute to this important forum, which has long served as a platform for meaningful dialogue and cooperation among competition authorities across the region. The theme of today's first session is recent developments in regulatory approaches to digital markets in Korea and Japan, as digital transformation continues to reshape economic structures and competitive dynamics. The role of competition law and policy in digital markets has become increasingly significant. We are particularly honored to welcome distinguished senior officers from both the Korea Fair Trade Commission, KFTC, and Japan Fair Trade Commission, JFTC. Their participation offers a valuable opportunity to gain first-hand insights into current enforcement priorities, regulatory developments, and policy perspectives in the 2 jurisdictions. Our first speaker is Director General from the Korea Fair Trade Commission, Mr. Jung-Kyu Sun. Mr. Sun has served as Director General of the Competition Policy Bureau at the KFTC since December 2025. He read in economics at Seoul National University and began his public service career at the KFTC in 2000. So let's invite Mr. Sun.
Okay, thank you, Professor Chair. My name is Jung-Kyu Sun. I am the Director General of Competition Policy Bureau in Korea Fair Trade Commission. It is a great pleasure to join this session today. I would like to begin by expressing my appreciation to the Japan Fair Trade Commission, the Asian Development Bank Institute, and ASCOLA, and all those who contributed to this organizing this meaningful session. It is an honor for me to take part in this discussion where we will exchange views on competition policy and enforcement in the digital sector, particularly from the perspective of Korea and Japan. Today, I would like to briefly share the Korea Fair Trade Commission's recent policy efforts and major cases related to digital platforms. Over the past decades, the rapid growth of the digital economy and online platforms has significantly transformed our daily lives. Digital platforms connect suppliers and consumers, enable innovative services, and have contributed to improving consumer welfare. They have also created new opportunities for small businesses, creators and self-employed workers by opening new channels for sales and service provision. However, there is not only a bright side. In particular, platforms often possess significant bargaining power over businesses that depends on them. This imbalance has increasingly led to conflict between platforms and their business users. These concerns are not merely theoretical. In 2024, the number of disputes filed with the Korea Fair Trade Mediation Agency related to online platforms increased by 45% compared to the previous year, showing the largest growth among all sectors. This trend increased that problems arising from platform-mediated transactions are becoming more frequent and more complex. At the same time, we have recognized that traditional competition law enforcement alone may not always be sufficient to address these issues in a timely and effective manner. So against this background, Korea has been discussing several legislative proposals aimed at ensuring fair transaction in the platform economy. Currently in Korea, two types of online platforms laws are being discussed in the Korea National Assembly. One is to address monopolistic issues in the platform market, and the other is to resolve unfair trade practice between platforms and their vendors. The current priority in the Korea National Assembly is focused on the second issue, which is to address the unfair trade practice. So today I will introduce the second approach. These proposals are commonly referred to as the Online Platform Fair Trade Act. I would like to emphasize that these bills are still under discussion in the National Assembly, so their specific contents have not yet been finalized, although I believe it is useful to briefly introduce their main policy directions. The proposed framework focuses on four key elements. The first element is transparency. Many disputes arise from unclear contract terms or frequent contract changes without timely notification to their users. To address this issue, the proposed legislation seeks to improve predictability by requiring platforms to clearly disclose key contractual terms that affect the rights and obligations of business users. This includes important conditions that could significantly influence transaction outcomes. By improving transparency, the goal is to prevent disputes before they occur and allow business users to better understand and anticipate platform practices. A second element is fairness. The legislation aims to prohibit unfair trade practices by platforms against business users. It also seeks to introduce platform-specific prohibited conduct reflecting the unique characteristics of digital markets. In addition, mechanisms such as fair trade agreements are being considered to institutionalize cooperation and coexistence between platforms and their business users. The ultimate objective is not to hinder innovation, but to promote sustainable growth based on fair competition. The third element is payment stability. This issue was from particular attention following several large-scale settlement delays and payment failures involving major platforms in 2024 in Korea. To prevent similar incidents, the proposed measures include clearly defining payment deadlines and requiring platforms to separately manage sales proceeds, for example, through escrow or payment guarantees. These measures are intended to ensure that business users can receive their payments in a stable and timely manner. The first element is dispute resolution. The proposal seeks to strengthen preventive and remedial measures for business users. This includes establishing a specialized dispute mediation body for platform-related cases and improving grievance handling systems. The aim is to provide practical and accessible remedies rather than relying solely on ex post enforcement of competition authority. I believe that the challenges of designing appropriate rules for digital platform is not unique to Korea. Competition authorities around the world, including those in Japan, face similar questions. How can we ensure fair competition without undermining innovation? How can we protect small businesses while preserving dynamic digital market? The Korea Fair Trade Commission continues to explore various policy tools to strike this balance. Now I would like to briefly introduce a recent enforcement case handled by the KFTC involving Kakao Mobility. Kakao is the most popular chatting app in Korea, and Kakao Mobility is its affiliated company, which operates platform related to taxi hailing service. In October 2024, the KFTC imposed the corrective orders and an administrative fine of approximately 10.27 billion US$ and referred the case to the prosecution. The case concerned abuse of market dominance in the taxi platform market. Kakao Mobility operates two kinds of businesses. The one is a general taxi hailing service through the Kakao T platform, and the other one is a franchise taxi service known as Kakao T Blue. In the general taxi hailing markets, Kakao Mobility held a market share of approximately 96% as of 2022. Since launching its general taxi services in 2015, the company expanded its influence by increasing the number of drivers using its service. In 2019, it further entered the franchise taxi market with the goal that all taxi calls would be handled through the Kakao T platform. After expanding its franchise taxi operations, Kakao Mobility adopted strategies that effectively excluded competing franchise taxi operators. Specifically, it required competing franchise operators to sign partnership agreements that demanded payment of fees for access to the Kakao T general call payment system and real-time provision of sensitive business information, including driver data and operational details. At the same time, Kakao Mobility warned that if such agreements were not signed, drivers affiliated with the competing franchises would be blocked from receiving general taxi calls through Kakao T. This conduct placed the competing franchise taxi operators in a difficult position. If they accepted the agreements, they were forced to provide core business secret information to a dominant competitor. If they refused, their drivers were denied access to a platform that controlled over 90% of general taxi calls, making it nearly impossible to sustain their business. In practice, some competitors signed the agreement, but the other one didn't accept the agreement, and they experienced severe losses of drivers and consumers. As a result, Kakao Mobility significantly expanded its position not only in the general taxi hailing market, but also in the franchise taxi market. Its market share in the franchise segment increased from 51% in 2020 to 79% in 2022, increased by about 30% in just 2 years. Meanwhile, competing franchise operators either exited the market or were reduced to marginal players. The KFTC concluded that this conduct substantially restricted fair competition and limited the choice available to both drivers and consumers. Taking these effects into account, the KFTC imposed corrective measures and administrative fines and referred the case for criminal investigation. This case demonstrates that leveraging dominance in one market to exclude competitors in an adjacent market can constitute an abuse of market power. And requiring competitors to provide sensitive business information may seriously undermine fair competition. We expect this decision to serve as an important signal to platform operators regarding the boundaries of lawful competitive behavior. In conclusion, online platforms play a critical role in shaping how market participants interact. Because platforms often operate globally and apply uniform business models across jurisdictions, international cooperation among competition authorities is essential. Through continued dialogue and collaboration, we can develop consistent and effective approaches that prevent market distortion while supporting innovation. Thank you very much for your attention.
Thank you so much. Mr. Sun actually introduced the current situation of the proposals of the possible new digital regulation, and at the same time, an important case of the self-referencing, especially in the taxi hailing service market. Our second speaker is Mr. Masaya Sakuma from JFTC. Mr. Sakuma has been Director General for Digital and International Affairs at the JFTC since April 2025. He joined the JFTC in 1992 after graduating from the Faculty of Economics at the University of Tokyo. It's really interesting that both speakers actually studied economics at the distinguished universities. So please welcome our second speaker.
Thank you, Professor Choi, for kind introduction and also for organizing this panel. It's great honor to hear with you, Professor and Director General Sun. So I'd like to thank everyone who engaged in organizing this conference. Before I begin, I would like to make it clear that anything I say is just my own personal opinion and doesn't represent the view of my organization. Recent rapid development in digital economy has brought about significant benefit, providing enterprise with a lot of business opportunities and consumers with a variety of conveniences. However, the digital sector is characterized by strong network effects, lock-in effects, and economies of scale. This leads a tendency for certain few digital platforms to gain a significant market power and an advantageous position over their business users, likely enabling the digital platforms to conduct anti-competitive practices. Therefore, JFTC has been actively engaging in digital field. Today, I'd like to talk about JFTC's recent initiatives in this field. I will divide my presentation into 3 parts. First, I'd like to introduce Japanese new legal framework for digital regulation, the Mobile Software Competition Act, or MSCA, referring to the background of the legislation on outline of the legal framework and the current situation of its implementation. Second, I'll move on to the JFTC's enforcement of the Anti-Monopoly Act. I'll mention recent important cases in which I'm interested. Third, I'd like to briefly introduce our survey on the current state of generative AI as a part of our advocacy efforts in digital field. Then let me begin by talking about the MSCA that is carefully crafted after meticulous research, studies, and deliberations. In Japan, formal government discussion on establishing fair and transparent rules for digital platforms began around 2018. The first major result of this momentum was the 2020 enactment of the Digital Platform Transparency Act. This act aims to enhance the transparency and fairness of transactions on designated digital platforms by requiring them to disclose transaction terms and relevant operational information. Online modes, app stores, and digital advertising platforms have been specified as subject to the act so far, and the act is enforced by Ministry of Economy, Trade, Industry, or MITI. However, subsequent government-wide studies revealed several challenges inherent in the mobile sector, particularly as smartphones have become essential infrastructure for both daily life and economic activities. Firstly, markets such as mobile operating systems and app stores have become highly concentrated with a duopoly. Secondly, anti-competitive behaviors by these platforms have led to pervasive competitive concerns. Thirdly, the market was found to have reached a state of no potential for market self-correction. Furthermore, the nature of traditional ex-post investigation is simply too time-consuming to respond swiftly in our rapidly evolving digital markets. Against this backdrop, the MSCA was enacted in 2024 as a complementary law to the Anti-Monopoly Act. The MSCA entered into full force on December 18 last year. As a result, the App Store sector was excluded from the scope of the Transparency Act to avoid regulatory duplication. MSCA covered 4 areas of software necessary to use smartphones, namely operating system, app store, browsers, and search engines. The Act imposes 9 prohibited acts and 5 compliance obligations on designated software providers. Under the Act, JFTC designates providers of 4 software applications with more than 40 million monthly active users in Japan as designated providers. Apple, iTunes, and Google have been designated as such providers. Crucially, MSCA doesn't target companies from any particular countries. It's based on an objective and non-discriminatory framework, meaning that any Japanese company exceeding the threshold will likewise be subject to designation. The MSCA prohibits designated providers from preventing offers of alternative app stores and use of third-party payment systems, engaging in anti-steering conduct, as well as preventing other enterprises from using the OS function that designated provider use. On the other hand, the Act allows designated providers to justify such prohibited conduct based on crucial factors such as ensuring security, protecting user privacy, and safeguarding minors. The Act also obliges designated providers to take certain measures, such as allowing users to easily change default settings to display choice screens for browsers and search engines, as well as to provide data portability tools. The JFTC published detailed guidelines in July last year to ensure transparency and predictability in enforcement. Unlike ex post regulation like the Anti-Monopoly Act, SMAC is a framework seeking to improve business models through continuous dialogue with stakeholders, including designated providers and app developers and so on. JFTC will promote compliance by designated providers through close coordination with related businesses, relevant administrative agencies, and overseas competition authorities. Having said that, if violations are identified through ongoing dialogue, or if a potentially problematic conduct is not corrected, or necessary legal measure will be taken. Before moving to the next topic, I'd like to add the current situation of the MSCA implementation. Compliance reports were submitted by the designated companies last December. These reports are currently undergoing internal review. The JFTC will publish them soon, excluding confidential business information. As you may be aware, the designated provider has already made updates in the business terms for app developers to comply with MSCA. For example, allowing alternative app stores and payment system, enabling developers to steer users to web-based transactions, and cutting commission rate. Furthermore, you may have seen a choice screen for your browser and search engine on your smartphone. And for me, I saw the choice screen last Friday. So I like to refrain from expressing my views on them. JFTC will continue scrutinizing whether the designated providers' initiatives are sufficient for legal compliance, while further listening to the voice of app developers and others, and then taking necessary steps. So next, I'd like to touch upon the enforcement of the Anti-Monopoly Act in the digital field. I strongly believe that Anti-Monopoly Act will continue to be crucial in addressing competition issues involving powerful digital platforms, even after the MSCA took effect. The JFTC has been rigorously and appropriately enforcing the Act in the digital sector as well. As part of these efforts, let me introduce two recent enforcement cases. The first case is Google search case, concluded in April 2025, marks the JFTC's first cease and desist order against the big tech company. In this case, Google engaged in the following two types of conduct that prevented other general search services providers from implementing the search function on certain Android smartphones. First, Google required the pre-installation and prime placement of its search and browser apps as a part of Google Play licensing agreement. Second, Google required the exclusion of rival search services as conditions for sharing advertising revenue. JFTC found these acts to constitute unfair trade practices under the Anti-Monopoly Act and issued a cease and desist order. The order prohibits Google from requiring the pre-installation or primary placement of its search and browser apps in conjunction with Google Play licensing, and demanding exclusion of rival search services as a condition for providing money. In addition, the order includes appointment of independent third party who will monitor the implementation of these measures for 5 years and report the result to the JFTC. When designing the remedial measure, JFTC considered a similar investigation by foreign competition authorities and the reference to their approaches, ensuring that the order was enough to restore competition among such service providers in the Android smartphone market. Next, I'd like to brief to the case against MC Data Plus as a data-related case. MC Data Plus is a leading cloud service provider for construction industry in Japan provides a labor safety service called Green Site. In this case, JFTC found MC data prevents Green Site users from switching to other companies' labor safety services by measures such as unreasonably refusing to provide worker information without reasonable justification, citing personal information protection as a reason, even though the Green Site users themselves registered the information. The FTC found these acts to constitute interference with competitor transactions, one fair trade practices under the Anti-Monopoly Act, and issued a cease and desist order. It is highly significant that the FTC addressed the dominant cloud service provider attempt to exclude rivals from access to workers' data owned by client companies. So FTC will respond to swiftly appropriate the rapid economic and technological changes brought about by digitalization and will actively take measures against any violation of the Anti-Monopoly Act. So finally, I'd like to share the JFTC initiatives on AI. The JFTC has been closely examining the impact of generative AI on competition. Let me briefly introduce our recent market study on generative AI. In June last year, the JFTC published a report on generative AI version 1.0. This study was conducted to understand the actual condition of market for generative AI from a viewpoint of maintaining a free competitive environment in Japan's generative AI market, ensuring the sustainable development of the technology to generate further innovation and integrating generative AI in a sound manner for economy and society at large. Given the fast evolving nature of the generative AI, our survey takes a more agile and flexible approach than traditional market studies, analyzing the data and trends, selecting key insights, and presenting the findings in a concise and focused format. The report organizes generative AI markets into 3 layers: infrastructure, model, and applications. It notes that big tech companies hold a competitive advantage, particularly in securing expert human resources and other essential inputs such as data and computing resources. The report also outlines the potential competition concerns at the Anti-Monopoly Act, including restrictions on access to specific software within mobile operating systems, data, specialized human resources, and others, as well as tying of generative AI model with existing digital services. At this stage, no clear violation of the Anti-Monopoly Act have been observed. However, the JFTC will continue its market research and update the report as the market condition evolves. Before concluding my book, I'd like to some comment. When it comes to emerging technologies such as AI, I think that it's still too early to determine what kind of regulation, if any, is necessary. It's essential to understand the market reality through careful research rather than drawing hasty conclusions. It's important to avoid hindering innovation and stifle technological progress. If the need for regulation became evident, the FTC would intend to take appropriate and well-balanced measures at that time. That's all my presentation. Thank you so much for your kind attention.
Thank you very much. Probably you can see some similarities and differences between two enforcement agencies in Korea and Japan. I would like to express my sincere appreciation to both speakers for their excellent and thought-provoking presentations. Together with my colleagues at ASCOLA, I have prepared a set of questions to guide our subsequent discussion with the aim of further exploring recent regulatory developments, enforcement experience, and future challenges in digital markets in Korea and Japan. We have almost like 20 minutes, so I prepared some questions, but like I'm not really sure whether I can just cover all the questions, but I will start with the self-preferencing case. It's really important nowadays, especially after the European Union's Google Shopping case. So my first question is, what's the current regulatory approach to self-preferencing in Korea and Japan, especially to what extent have Korean competition law and enforcement evolved following the Supreme Court's judgment in the last year? Actually, there were two neighbor judgments. That's the question to Mr. Sun. And in Japan, does the recently enacted Mobile OX Act affect the assessment or treatment of the self-preferencing under existing Anti-Monopoly Act? So, Mr. Sun.
Okay. Yeah. Thank you. At present, Korean law does not explicitly regulate self-preferencing as a separate state-alone category. But the KFTC has addressed the self-preferencing by applying existing provision as abuse of market dominance, such as interference with competitors' business activities, or as unfair trade practice, such as discriminatory treatment or providing disadvantages. In practice, we have handled self-preferencing conduct by dominant platforms in sectors such as text dispatch platforms and search engines. The example includes the Kakao mobility case. This is different from my presentation, and as well as the neighbor shopping and video case. As a moderator mentioned, KFTC determined the neighbor shopping self-preferencing practices significantly hindered competition and imposed administrative fines and corrective orders in 2021. The High Court upheld the Korea Fair Trade Commission's decision. However, the Supreme Court decided that the KFTC decision didn't sufficiently prove the anti-competitiveness and returned the case to the High Court. I think the Supreme Court decision in the neighbor shopping case has been interpreted as requiring stronger proof regarding the anti-competitive intent, purpose, and effects in abuse of dominance cases. In response, the KFTC plans to further strengthen rigorous evidence gathering and economic analysis in similar cases going forward. In addition, in 2023, the KFTC established the guidelines for review of abuse of market dominance by online platform operators. In these guidelines, we identified self-preferencing as one of the major conduct types that may raise competition concerns in online platform market. We also specified concrete factors to be considered when assessing irregularity, thereby enhancing predictability and transparency in enforcement. Finally, I would note that multiple bills, as I mentioned, aims at addressing monopolization by platform operators are currently pending in the National Assembly, and the KFTC will continue to participate faithfully in those legislative discussions. Thank you.
Thank you. Mr. Sakuma, please.
Thank you, Professor. That's a great question. So, in my view, the Anti-Monopoly Act would prohibit enterprises from self-preference practices without reasonable justification where they have anti-competitive effect on competition in the market. Or typically, if influential big tech companies engage in such conduct as may prevent new entrants or may make it difficult other enterprises to continue their businesses, they may fall in violating the Anti-Monopoly Act. MFCA includes provisions which prohibit designated providers from self-preference practices, such as preventing the provision of a third-party app store or self-preferencing in such services on smartphones. That's because if designated providers engage in such practices, it's most likely that they will violate the Anti-Monopoly Act. In other words, the principles antitrust law, Anti-Monopoly Act served as a starting point for drafting the MSCA provisions. So I think that the MSCA may not have influence on the treatment of the Anti-Monopoly Act. That's my personal observation.
Okay, thank you. Well, you can see some similarities and differences again between two agencies because personally, I think Japan focuses more on the Mobile OS Act, so there is no actually public enforcement against the self-preferencing in Japan, but whereas Korea has some cases, not only 2 cases of their neighbor, also there are some 2 important cases like Kakao Mobility, also the Coupang pending in front of the court. So you can see in the future how it works in Japan and Korea. Maybe maybe in the same way, maybe some differences. So you can find out within a few years. Second question is about UTP, unfair trade practices, which is really important in both countries. So to what extent do Korea's and Japan's rules on unfair trade practices applicable to digital platforms contribute to a fairer marketplace, online marketplace, and society? First, Mr. Sun. Okay.
Korea has been regulating unfair trade practice in digital market primarily through existing legal frameworks, including the Monopoly Regulation and Fair Trade Act and the Act on Consumer Protection in Electronic Commerce. To strengthen enforcement specifically against unfair conduct by dominant online platform operators, as I mentioned, the KFTC established the guidelines for review of abuse of market dominance by online platform operators in January 2023. In 2024, the KFTC also imposed remedies and a fine of approximately $114 million on Coupang for manipulating its search algorithm and having employees post reviews, thereby promoting its own product through preferential top placement. Overall, active enforcement against digital platforms contributes in tangible ways to a fairer marketplace and society. It helps promote competition in digital markets, protect small merchants and business users, including those operating on platforms, and strengthen consumer protection. At the same time, as the influence of major platforms continues to grow, the need for legislation to promote fair competition in platform has also become more evident. Relevant bills, as I mentioned in my presentation, are currently pending in the National Assembly, and the KFTC will continue to actively support the legislative discussion so as to help create a fair and sound digital market environment going forward. Thank you.
Thank you. Mr. Sakuma?
Yes, thank you. So I think that addressing the unfair trade practices has recently been occupying a significant part in the JFTC's enforcement activities in the digital field. Abuse of superior bargaining position is so relevant to it because the characteristic of the digital market tends to get a certain few digital platforms or more an advantageous position over their business users, as I said earlier. The JFTC already took legal measures against Rakuten and Amazon Japan in 2020 regarding abuse of superior bargaining position. In the Rakuten case, the JFTC filed a petition for an urgent injunction to the Tokyo District Court against shipping inclusive program measures proposed by Rakuten, by which all the merchants of Rakuten Ichiba would be prevented from receiving delivery fees from purchasers. In Amazon case, the JFTC approved the commitment plan applied by Amazon Japan, which was related to the allegation that Amazon Japan had pressured suppliers in a weaker bargaining position to cover lost profit from Amazon's price discount and forced them to pay for system upgrades. The commitments, including the stopping the suspected conduct immediately, refunding around 2 billion yen, and establishing an internal compliance system, and so on. These enforcement activities have contributed fairer competition in Japanese e-commerce sector through prevention of unjust disadvantage by the early intervention or recovery of losses incurred due to the alleged acts. I would also likely touch upon some rules in MSCA. This stipulates provisions regarding easy change default setting, choice screens for browser engines. I believe that these provisions will not only give the consumer more choice, but business more incentive for competition to attract consumers. I believe that overall Japanese digital law enforcement and regulations will continue to consumer benefits and market development by ensuring fair competition in the marketplace.
Okay, thank you. Both the speakers actually introduced the two important kind of cases. One is actually Rakuten and the Amazon at the same time, Coupang in Korea. So where I think the both the agencies focus more on the fair kind of the transactions based on the relying on the provisions on unequal bargaining power, especially in the e-commerce sector. That's what I personally found. And one more thing is about actually Mr. Sun talked about the Coupang case, which is really important nowadays in Korea. And well, I think it's related to also a neighbor case. Personally, I agree and also disagree with the judgments of the Supreme Court, personally. And because the KFTC has applied actually not only rule on abuse of market dominance, but also the UTP provision. And so we can find out in the future, whether that kind of legal test, by the Supreme Court will be effective in following cases like Coupang or the Kakao Mobility. Third question is about the data. So data is really important nowadays in the digital market. So what competition policy responses might emerge to address the competitive concerns related to data? For example, data access, data portability, and interoperability, and data-driven foreclosure. So this time, probably Mr. Sakuma can talk first.
Yes, thank you. So in the data economy, sorry, skipped this one. So it's crucial that Competition Authority appropriately address the potential competition concerns that data accumulation may pose. I'd now like to briefly mention the data-related endeavor by the Fair Trade JFTC regarding merger levy activities because we have already taken up non-merger cases. In 2019, the JFTC revised its merger guideline and its policy on merger review procedure to effectively address mergers and acquisitions in this data sector. The revised merger guidelines describe how to consider the network effects and the value of data in the market definition and analysis of the competitive effects. Furthermore, the revised policy makes clear that regarding merger plans not requiring notification, if the total consideration for the acquisition is expected to exceed 40 billion yen and the plan is expected to affect domestic consumers, the parties involved are encouraged to consult with the JFTC. It addresses concerns that even merger plans involving high-valued data where competitive issues may arise could slip through the notification threshold based on sales figures, which will preclude an effective merger review. So, for example, in line with this policy, JFTC reviews the planned acquisition Fitbit by Google, even though this acquisition didn't meet the notification threshold. Thank you.
Thank you. Mr. Sun, please.
Okay, thank you. The KFTC last year conducted a market study under the theme of data and competition and published a policy report. You can find this report in our website in English version. Through this work, we examine how data, one of the core elements of the digital economy, is collected and used in Korea's digital markets, identified related competition and consumer issues, and presented directions for future competition policy. The study found that active competition is taking place in Korea's digital markets in the process of collecting and using data. At the same time, as digital services become more sophisticated and the importance of data continues to grow, we also confirm that new forms of potentially anti-competitive conduct may emerge. This include, for example, restriction on interoperability or foreclosing rivals by involving personal data protection as a justification. We also observe that some businesses do not fully recognize the potential competition law risks that may arise in the collection and use of data. In addition, some stakeholders emphasize that in certain digital areas where competition is limited to only a small number of platform operators, or more active role by the competition authority is needed. Against this background, the KFTC will continue to closely monitor whether anti-competitive practices arise in relevant market. In response to new forms of unfair practice, we will consider appropriate measures, including improvement to the relevant legal and policy frameworks. More broadly, the KFTC intends to pursue policy researches on emerging markets in a continuous manner so as to respond proactively to evolving issues. Following our 2024 report on Generate AI and competition and our 2025 report on data competition, we plan this year to focus our next study on AI downstream services and competition. Thank you.
Okay, thank you. Well, actually, I have one more question, but because of time constraint, probably it's about the time to wrap up this session. And my last question was about the international cooperation between agencies and how to improve the enforcement, especially related to the shaping and regulating digital markets. But this question maybe in the agencies need to think about the this issue in the future. So it's about time to wrap up. So thank you very much, and please give our speakers a well-deserved round of applause. Thank you.
Session 2. Right. Session 2, we are honored to have Dr. Yesem Erelhan Kayara, from the Asian Development Bank as a speaker, and Commissioner Reiko Aoki of the Japan Fair Trade Commission as commentator. So, drawing on more than 35 years of experience in development institutes and academia, Dr. Kayara will deliver her keynote, Building Together, Adapting Smart Digital Competition Policy for Asia's Diverse Economies.
Thank you very much. Chair Chatani, JFTC representatives, representatives from the esteemed competition authorities across the region, Professors Wakui and Cheng, and Askola colleagues, and of course my colleagues from the ADVI joining us today. Distinguished guests, colleagues, ladies and gentlemen, good morning. As inaugural co-host of this 17th East Asia Conference on Competition Law and Policy, it is an honor and a rare privilege for me to join you, leaders from competition authorities, legal scholars, economists, practitioners, united by a shared conviction. How we govern digital markets will shape the economic future of the Asia-Pacific region. Digital markets are reshaping competitive dynamics across every economy represented in this room today. The tools developed in the analog era are no longer sufficient, and today I will explore why, what the region is already doing, and how we can learn from one another while preserving the diversity of approaches that constitutes our greatest strategic asset. Digital platforms transcend development levels. The same handful of global firms, Google, Apple, Amazon, Meta, operate uniformly across Tokyo, Manila, and Dhaka, exercising market power regardless of the regulatory context in the host country. Platforms now mediate trade, mobility, payments, travel, and social interaction across the Asia-Pacific region, and more. Without deliberate responses, the digital divide becomes a governance divide. The opportunity we have is extraordinary. ASEAN alone reached $300 billion in digital economy gross merchandise value in 2025, 1.5 times the initial estimate, with $135 billion in revenues as profitability continues to accelerate. Regional projections show $1 trillion by 2030. More optimistic ones double that amount with successful implementation of frameworks like the Digital Economy Framework Agreement, the DEFA. This growth must be channeled to ensure competitive services deliver consumer welfare, data governance, and genuine economic inclusion. Opportunity exists for those ready to seize it. Economies still shaping digital regulatory architecture are not burdened by legacy frameworks. They can leapfrog, learning from others without repeating mistakes, shaping growth rather than retrofitting solutions. Across the Asia-Pacific region, economic imperatives may differ in detail, but they converge in direction. Advanced markets must protect innovation ecosystems from platform dominance. Emerging markets must prevent digital entrepreneurship being crowded out by entrenched incumbents. Every market depends on competitive services for consumer welfare, data governance, and genuine inclusion. The challenge is traditional enforcement is difficult or not fit for purpose in digital markets. Network effects tip markets toward dominance in months. Zero-price services defeat conventional price analysis. Platforms leverage dominance across markets, strong network effects, low marginal costs, data advantages, and ecosystem expansion reinforce incumbency while new entrants struggle to scale. This creates barriers to entry, self-preferencing, and lock-in. Cases take years, during which time dominance becomes exponentially harder to unwind. We see that ex-post enforcement alone is not sufficient. We need preventive tools deployed at digital market speeds. Traditional merger control faces challenges. Killer acquisitions where platforms acquire competitors to eliminate them demand thinking beyond traditional thresholds. Below threshold mergers, data accumulation barriers, and assessing future rivalry constitute live enforcement questions, as we've heard both yesterday and this morning. And Asia-Pacific has acted. Japan's Transparency Act, Korea's In-App Payment Act, Australia's Digital Platforms Inquiry, India's ex-ante frameworks. The region is shaping global trends. If digital platform governance defined last decade's competition challenge, artificial intelligence defines the next. Concentration risks in AI are both familiar and distinctly new. Foundation models, large-scale AI systems underpinning accelerating commercial applications require extraordinary data and computing power. Control of chips, computing, cloud infrastructure, and foundation models rest with few global firms. Southeast Asia has growing data center presence. Capacity increased from 120 to 690 megawatts in the first half of 2025, with 350% expansion planned. Over $55 billion in AI infrastructure commitments flowed to the region in 2025, from Microsoft, Google, AWS, to Malaysia, Thailand, Indonesia. Data centers will consume 68 terawatt hours by 2030, up from 9 terawatt hours in 2024. Excuse me. However, the region has limited influence in the upstream layers that determine access, pricing, and technical standards. Cloud infrastructure is dominated by 3 to 4 providers. Access to this infrastructure determines whether AI developers can compete at all. This reliance on external providers introduces vulnerabilities that can affect competition across entire digital ecosystems. AI infrastructure access gates innovation. Algorithmic systems can generate coordinated outcomes without intention. Data concentration strengthens incumbents. Firms controlling AI leverage this into downstream markets, search, content, and enterprise software. Self-preferencing is likely to replicate in AI-adjacent sectors, and vertical integration increases switching costs. AI mergers may consolidate compute and data with long-term innovation impact. Consider, for instance, firms simultaneously developing AI models, operating cloud infrastructure, and selling consumer products. Leveraging dominance at each layer is precisely what competition policy must address. Yet we face institutional realities, silos, agencies with discrete work streams, which complicates our response. For instance, in Thailand, AI portfolio is with the Ministry of Digital Economy and Society, competition with the Ministry of Commerce. In Cambodia, AI-related policy is with the Supreme National Economic Council, competition with Ministry of Commerce. Malaysia, Ministry of Science and Technology and Innovation looks after AI, and competition is with the Ministry of Domestic Trade and Cost of Living. This goes across the countries, and the pattern repeats at regional level as well. One example is from the ASEAN. ASEAN has made noteworthy progress in developing regional cooperation mechanisms for both competition and AI governance. The member jurisdictions concluded the ASEAN Framework Agreement on Competition Negotiations, strengthened implementation of the Competition Action Plan, ACAP, 2016-25, and expanded regional platforms for coordination and peer learning. In parallel, ASEAN has advanced initiatives on digital governance and responsible AI under the ASEAN Digital Master Plan, ADM 2025, the ASEAN Guide on AI Governance and Ethics, the expanded Guide on Generative AI, and the ASEAN Responsible AI Roadmap. We're not short on effort. However, these streams of work remain institutionally separate. Competition cooperation is led through the ASEAN Experts Group on Competition, AEGC, while AI governance is driven by the ASEAN Digital Ministers, ADG-MIN, and the ASEAN Digital Senior Officials Meeting, ADG-SOM, and the ASEAN Working Group on AI. Meanwhile, DEFA, the Digital Economy Framework Agreement, negotiations add a third governance track led by trade and economic officials. Limited cross-representation across these bodies has resulted in fragmented oversight of AI-enabled markets with few structured mechanisms for addressing competition issues arising from AI adoption. Timing compounds this fragmentation. Most competition frameworks were established well before AI emerged as a policy priority and became central to economic activity, in some cases decades before. Philippines, an act to prohibit monopolies and combinations in restraint of trade, the precursor to the current competition law, dates to 1925, followed by the, as I mentioned, the contemporary Competition Act in 2015. Laos Law on Competition and Singapore Competition Act were first introduced in 2004. National AI strategies, by contrast, are constructs of the last 5 years. The institutional silos created by mandate and time are not merely bureaucratic inconveniences. They're structural barriers to coherent policy. When competition authorities lack technical expertise to assess AI market dynamics, and AI regulators lack economic and legal frameworks to identify anti-competitive conduct, the gap between policy intent and enforcement reality grows dangerously wide. Enforcement activity remains concentrated in a handful of jurisdictions, and most authorities face constraints in evaluating algorithmic behavior, data-driven market power, and cross-border platform conduct. Synchronization is therefore essential. Competition authorities and AI policy bodies must develop formal mechanisms for information sharing, joint market analysis, and coordinated enforcement. This does not mean merging institutions. The expertise required for each domain is too specialized. It means creating structured channels through which AI governance informs competition assessment and competition principles shape AI regulation. The second challenge we face concerns scale and geography. AI markets are inherently global. A foundation model trained in California powers services delivered in Kathmandu, Ulaanbaatar, or Wellington. Competitive effects ripple across borders instantly. Individual jurisdictions are challenged to address cross-border dynamics alone. In fact, no single national authority can fully assess, prevent, and remedy harm manifesting simultaneously across multiple jurisdictions. Regional coordination becomes operationally necessary. A robust architecture for coordination in regulating AI stack markets becomes necessary. We already have the building blocks: national expertise, shared challenges, bilateral cooperation, excellent forums like the EA Top, and knowledge events such as the EAC. But systematic intelligence sharing, joint investigations, and coordinated remedies are yet to come. Coordination across competition, digital, and trade bodies must ensure AI governance supports contestable markets through shared analytical capacity. Digital competition and AI strategy are interlocking, they're not sequential. Industrial, trade, and technology policies shape market structure. Competition principles must be integrated at policy design, not retrofitted afterwards. Ideally, when governments invest in AI infrastructure, competition authorities should be consulted to preserve contestability. When trade negotiators design data governance provisions, competition concerns, particularly cross-border data concentration, should inform those provisions from the outset. In this context, the practical implication for competition authorities is threefold, if I may. First, build analytical capacity to assess AI markets now, not when the first enforcement case arrives. Second, establish formal coordination mechanisms with AI policy bodies nationally and counterpart authorities regionally. Third, engage proactively with industrial and trade policymakers to ensure competition principles are embedded in economic strategy from the beginning and not retrofitted as afterthoughts. Indonesia and Thailand are exploring, for instance, the digital platform guidelines extendable to AI-specific market dynamics. India's CCI has demonstrated through e-commerce market studies that rigorous analytical groundwork can inform targeted enforcement well in advance of formal litigation. Over 680 AI startups across Southeast Asia have attracted more than 2.3 billion in investments, accounting for 30% of private funding in the first half of 2025. This growth trend is expected to continue, and a forward-looking cross-governmental policy design is what this moment demands of us. The temptation when facing global challenges like platform dominance is to seek uniformity. A single regional standard, a single set of rules, it's understandable, but not realistic. Digital maturity varies enormously across the Asia-Pacific region. AI governance ranges from strategies and draft legislation to broader digital agendas. Capacities differ by orders of magnitude. Economic structures and priorities are distinct. What works for mature authorities may be premature or even potentially damaging elsewhere. Principled flexibility is the alternative. Japan, Singapore, Korea, and Australia each offer lessons: transparency, scalability, targeted regulation, evidence-based foundations reflecting their respective jurisdictional realities, some of which we've heard over the last 2 days. Key principles to consider are: adapt frameworks to local context, scale ambition to capacity, prioritize local market failures, and share learnings candidly and continuously. In practice, this means tiered criteria, core principles on data portability, interoperability, and transparency with flexible implementation, information sharing, joint capacity building, and coordinated investigations. A coordinated approach can help the region capture AI benefits while safeguarding fair competition and innovation in our markets. And we're ready to do our part. Development organizations like the Asian Development Bank and our esteemed think tank, ADB Institute, possess a unique convening power to bring authorities, policymakers, and practitioners across market sectors and borders. ADB's competition policy initiative supports this collaborative approach through technical assistance, knowledge partnerships, and operational support. And we're not alone in this effort. The World Bank, UNCTAD, OECD, and ASEAN frameworks join the drive to facilitate peer learning and to pool expertise at scale. Effective support is contextual and collaborative, creating space for jurisdictions to learn from one another and contextualizing these lessons for each economy's distinct realities. That space itself is a public good. In conclusion, the digital economy demands that we act now, not after every question is answered. Digital technology and AI-backed markets are evolving rapidly, and the competitive structures we establish today will shape our economies for generations to come. But we cannot act in isolation. Speed without coordination creates fragmentation. And fragmentation leaves all of us, our businesses, our consumers, our societies, more vulnerable. The path forward requires collaborative diversity, united on principles, flexible on execution, and genuinely committed to learning from one another across this extraordinary region. This is not just a framework, it is a call to action for all of us gathered here. Let's use this conference to move from dialogue to concrete next steps. Let's identify where we align our approaches, where we can pilot joint initiatives, and how we can build the modalities to learn from each other in real time. Together, we have the opportunity to shape markets that work for everyone in our region. We at the Asian Development Bank are committed to working alongside each one of you to turn these ambitions into reality. Let's adapt smart and build together. Let's begin. Thank you for your attention.
So I may have been overwhelmed by the challenges, fragmentations, but the key was here probably principled flexibility and collaborative diversity. Thank you. Yes. Okay, then could you give us the comments, Professor Aoki-Reko-sensei, please?
Thank you. Thank you, Yasmin. I'm going to call you Yasmin. Your last name is too long for me. Everybody can call me Reiko, which rhymes with Seiko, by the way. It was, thank you so much for your illuminating and inspiring talk. I'm afraid my comments cannot do justice to what you have said, but I'll do my best trying to complement and things that you have suggested and reviewed based on what I know about competition and AI. And first of all, I could not agree more than what you said about how authorities need to build analytical capacity to assess AI markets now, not when the first enforcement case arrives. Second, establish formal coordination mechanism with AI policy bodies nationally and counterpart authorities regionally. And third, engage proactively with industrial and trade policymakers to ensure competition principles are adhered to. And as advisor to the ADB, which has just joined the EATOP family, welcome. Your emphasis on the convening power of ADB is very illuminating and appreciated. I particularly like Wakui Sensei, the expression collaborative diversity. I think that is very important for us. And as you said, the risks in AI are both familiar and distinctly new. So I'd like to extend a little bit on the déjà vu aspect and also extend a little bit on generative AI based on the JFTC market study that Sakuma Shingikan talked about earlier, which is available in English, by the way. So I'll start partly with, first with trade. As you know, in the book that you edited with ADBI last year and JFTC contributed, we identified how there was a relationship between joining the WTO and getting the competition policy framework seemed to be highly correlated. And this almost seemed to be having a coherent competition policy was almost necessary to join the World Trade Order. But I also think, what actually has happened is that the general agreement in trade and tariffs that got working around started in 1986, and it ended in 1995 with the establishment of the WTO. And actually, many Asian economies joined the WTO immediately, including Hong Kong, China, India, Indonesia, Japan, Malaysia, the Philippines, Republic of Korea, Singapore, and Thailand. And some Asian countries such as Cambodia, Taipei, and Vietnam joined a few years later. And there's evidence, as I said, there's evidence that joining the adoption of competition policy was a condition, almost a condition for joining the WTO. But the sequence of events, as I just mentioned, doesn't quite match what's happened. Another thing that happened as a result of WTO is that the organizations such as International Competition Network, the ICN, was started in 2001. ETOP started in 2005. Clearly after a few years after WTO was started. And this seems to be partly because as global trade expanded, there was emergence of international cartels, which required international coordination to tackle. And in fact, Global Antitrust Conference mentioned yesterday, which takes place in Fordham every year, was started with, at Fordham Law School, was started around the same time that ICN came into effect. And in fact, there is a speech by head of the US authority when the International Global Antitrust Conference started at Fordham Law School that called for concerted efforts to tackle international cartels. So it is no surprise that the new global competition challenge from AI is giving rise to a new framework set forth by Aspen. It is natural that ETOP, a regional complement to the global framework such as the ICN, will have its own approach to the new generative AI challenge. So what is the regional significance of that EATOP can accomplish? in the face of the new Gen AI challenge. This is probably because member countries of EATOP each have a different relationship to the 3 layers of general AI stack. At the bottom of the stack is the infrastructure layer made up of computational capacity, such as semiconductors, such as GPUs, data, and expertise or very specialized talent. Above that layer is the model layer, built with semiconductor trained, using data by specialized talent. And at the top is the application layer consisting of various services such as text generation, code generation, and visual image generation. I will not repeat the possible anti-competitive behavior that can occur at each layer or across layers. I just note that each country finds different layers or part of the layer relevant. Furthermore, there's heterogeneity of GPUs and data corresponding to different computing intensities. For instance, training phase and inference phase of LLMs require different types of computation and therefore different GPUs. Similarly, there's a general purpose data and there's high quality data necessary for specific use. And as we know, semiconductor production itself comes in different stages, and as is well known, and stages can be completely different or they can be related. And specialized semiconductors and data are produced at scales feasible. Some specialized semiconductors and data are produced at scales feasible for many small economies. So scale and geography noted by Yasmin is very true. Please read the report regarding generative AI version 1.0 published by the JFTC last June for more details. It is available in English. There's a one-page summary which is very informative. Importance of data adds another heterogeneity to the mix. Data and privacy is part of consumer protection. Data is also related to copyright and other IP policies. Both of these frameworks differ by country, and I think firms, in fact, would appreciate some coordination or at least communication among agencies. And of course, agencies ourselves will benefit from coordination, exchange of information. How new digital tools are used in the courts, I mentioned by Thomas in the opening speech, I think is another challenge that we're all beginning to face. We found yesterday many agencies are engaged in data scraping, screening bids with digital tools, but in most cases, how it will stand up in court is yet to be found out, hopefully in a positive way. But how we can better use these tools in the court would be another challenge that we agency could share as part of the information of the exchange. I hope I have convinced you that each layer of generalized stack is diverse and relationship of each stack differs by country. There will be diverse collaboration, and there's reason for collaboration among ETOP countries. And during Thomas's speech, I also thought of another collaboration that we could probably speak of. So we have many experts and agencies now. So we've had economists, we had digital IT specialists, And of course, we have lawyers, and they need to speak to each other within agencies. And I think this is another new challenge that Gen AI has posed on us. And we have been talking about a network of specialists within ETOP. So there will be a group of economists, there will be a group of IT specialists, group of lawyers that will be communicating. And one of the informations that probably could be shared is a strategy for speaking to other specialists in their respective agency, and including speaking in the courts. I hope this will be included in part of the exchanges that will be made in the future. And finally, I would like to thank Yasmin again for a very illuminating and inspiring keynote speech. Thank you.
Thank you. Then I would like to invite comments or questions from the floor. Is anyone, Thomas Beck? Yes, please.
If I may, thanks a lot for these two presentations that were very inspiring policy-wise. I've also a policy-related question coming from the European Union, so a bit the outside view here. Thomas Wake, my name, from Frankfurt School of Finance. I noticed some underlying tension in what you were saying, because on the one hand it was said agencies should intervene even if not, or policymakers at least should intervene even if not every question has been answered yet. We are in a fast-moving environment, so this is well understood. On the one hand. On the other hand, though, we see a trend towards ex-ante regulation, particularly when it comes to digital markets and AI, which is quite detailed regulation. So we also can expect particularly big tech firms to challenge each policy move and each agency intervention to the extent they can. Now, two questions based on this. As we are in jurisdictions that also value the rule of law, obviously these challenges can then pose obstacles to quick intervention. And so first question, would it make sense from your perspectives to focus particularly on the infrastructure level, broadly understood, when we talk about the AI stack, so data, talent, energy, and compute, to make sure that we can have an impact, basically, with interventions that then translates into the other onto the other layers, basically, of the AI stack, and not focus so much on the application layer, for example, or the foundational layer, foundation model layer. And second question, would you see that developing country members of ASEAN, for example, may have different priorities to pursue in this context as compared to more developed markets and more developed jurisdictions? Thank you.
Shall we collect a few questions, or shall I respond? Absolutely, then we immediately respond. Thank you very much for that great question. And I believe you've answered it partially for me as well. Thank you for that also. 2 points there. One of them is that we cannot wait for everything to be signed, sealed, delivered, all the jurisdictions to agree on local, national, regional laws before we start educating ourselves and the stakeholders to demand more of the market and the entrants and the incumbents dominating in the market. That's the point. So it is important not to think of it as either or sequential, but concurrent activities. Be ready, because it does take time to put legislation that is acceptable to all in motion. even when it's approved, when the competition acts across ASEAN, you mentioned, for instance, when they came in, it took some time for enforcement to start, for all the different implementation layers to come through. But in the meantime, market is changing, and information that's coming through a changing market can in fact inform implementation as we finalize perhaps the overall frameworks themselves. That's the point that I would encourage for further consideration. That's one element. The second element, in terms of the AI stack, I believe Reiko also made that point very clearly. What we're looking at is not, let's do everything sequentially, all of us in the same manner. What we're looking at is different countries are going to need to come in faster at certain points because of their localized market failures and the demand and the maturity of not only the market structure, but also the regulatory framework, also the AI and digital architecture that exists in that market. What makes it challenging is that we're trying to govern locally with international parties. And that's the point where regional perhaps could come in through the strength of many and coordination. It's not uncommon for some of these companies to form shop. They follow where jurisdiction allows them more freedom. However, coordinated efforts, in fact, even coordinated investigations, limit that option. And perhaps we can move forward much faster because everybody is on the same page. ASEAN versus Europe, that is a much longer conversation perhaps, but one has to be careful. ASEAN is also very large economies. It also includes Singapore, for instance, that dominates as the AI hub since 25 perhaps in Southeast Asia. It also includes very, very large-scale economies, like Indonesia, for instance, a very broad spectrum of economic activities, like Philippines. So it's not, perhaps it would be advisable for us not to think of regions as being uniform within themselves and distinct from each other, but again, target the local immediate need and how we may be able to address that one. Hope that addresses the query.
Yes, so we have to finalize this session, I'm afraid. You must have more questions and comments, but ADB is continuing on supporting us, I think. So there will be opportunity to have dialogue with you. So hoping that. By the way, Professor Thomas Beck is co-chair of ASCOLA Germany. We collaborate. Scholars also collaborate globally. Okay, with this, we have to conclude this session. Thank you so much.
Thank you.
Third and last session is about Indonesia, which is moderated by Professor Arisa Wakabayashi. Wakabayashi, please.
Not good morning anymore. Good afternoon, everyone. So now, this is the final session of EAC. This session focuses on Indonesia and is entitled The Indonesian Competition Law Landscape. It's been 25 years since Indonesia enacted its competition law and established its competition authority. In this session, we will explore a bit of Indonesia's experience to date, the current state, and the outlook for the future. My name is Arisa Wakabayashi. I'm a professor of Kumazawa University Law School and the moderator of the session. First of all, let me introduce the speaker for this session, Commissioner Eugenia Mardanugraha of KPPU. Sorry for my pronunciation. And Dr. Eugenia currently serves as a commissioner of the Indonesian Competition Commission, also known as the KPPU. Before her appointment to the KPPU, Dr. Eugenia established herself as a distinguished lecturer and researcher at the University of Indonesia. While distinguished while her expertise as a microeconomist led her to teach subjects such as monetary economics and econometrics. She has dedicated a significant portion of her career to the field of antitrust economics. Her influential research has tackled critical market issues, including her 2018 paper on cartel evidence in the Indonesian garlic trade and her recent 2025 analysis regarding the economic implications of the amended competition law. And Commissioner Eugenia would like to make her presentation interactive. So on the way of her presentation, I will make some questions. After answering my questions, she continues her presentation. So Eugenia-san, please start your presentation when you're ready.
Okay, thank you. Good afternoon, everyone, distinguished chair, respected speakers, ladies and gentlemen. First of all, I would like to express my sincere appreciation to JFTC, ADB, ADBI, Askola Asia for organizing this, the organizing committee of the 17th East Asia Conference on Competition Law and Policy EAC for the excellent organization and for this for the opportunity to speak today. Thank you, Professor Arisa, for moderating this session. It is an honor to be part of this important forum that brings together competition authorities, scholars, and practitioners from across the region. I am Eugenia Madanugraha, currently serve as a Commissioner of Indonesia Competition Commission, KPPU, for the 2024 to 2029 term. I am pleased to share with you a presentation that explores Indonesia's experience supervising and enforcing competition policy across different markets, highlighting key lessons learned from regulatory practice. The presentation also discusses the evolving landscape of the economy and financial markets, and outlines the future challenges faced by competition authorities in ensuring fair competition, transparency, and market integrity amid increasing market complexity and digitalization. Through this presentation, I will reflect Indonesia's experience in enforcing competition law over the past 25 years, the institutional development of KPPU, and the key challenges we face going forward. Over the past 25 years, KPPU achieved can be grouped into three main areas. First, enforcement outcomes have produced measurable benefit for consumers and markets. Through cartel, bid rigging, and abuse of dominance cases, KPPU has helped restore competitive conditions, lower prices, improve market access, and enhance consumer welfare across key sectors. Second, institutional innovation that have modernized enforcement practices. KPPU has gradually strengthened its analytical capacity, integrated economic analysis into case handling, and developed internal procedures that supports more consistent, evidence-based, and transparent decision making. Third, successfully advocacy and compliance effort. Beyond enforcement, KPPU has actively engaged with government institutions, state-owned enterprises, and market players to reduce regulatory distortion, promote fairer rules, and prevent anti-competitive conduct before it occurs. Together, this achievement reflects KPPU evolution from a young authority into a more mature competition agency with a broader impact on Indonesia market economy. I would like to hand the session back to Prof. Ariza. I hope this discussion will facilitate the in-depth exchange perspective, allowing key issues to be addressed in a flexible manner while responding to the natural flow of the conversation.
Thank you. My first question, I understand that legal amendment is currently underway in Indonesia. I think legislative reform is a challenge for competition authorities in any country. In particular, securing the understanding and cooperation of a wide range of stakeholders, including business communities, policymakers, and consumers in general, is very important, but also not easy. So from that perspective, advocacy is crucial, I think. Could you share how KPPU has approached its advocacy efforts?
Okay. The legislative amendment process and internal efforts undertaken to modernize competition law enforcement in Indonesia. On the legislative side, amendments have been pursued through multiple channels. At least three multiple channels. Yeah, one of these include the introduced under the Omnibus Law on job creation, as well as further modernization through implementing regulations issued by the Commission and the Chairman. Together, this effort aimed to update the legal framework while broader statutory reform continues to be discussed. The legislative amendment process is currently processing, with the House of Representatives actively discussing the academic paper that is prepared in collaboration with legal and economic experts throughout the country, to not just in Jakarta, but also to the expert legal and economic in region. KPPU has also been involved in this discussion, providing technical inputs and practical perspective based on its enforcement experience. This stage is particularly important to ensure that draft amendments to the law are conceptually sound, legal coherent, and free from potential implementation issues before moving to the next phase of legislative process. Collaboration with the universities has played a significant and complementary role in this process. Academic partnerships have helped strengthen this intellectual foundation of competition policy by fostering research, critical debate, and capacity building. Universities have served as an important platform for developing future competition practitioners, training judges and regulators, and disseminating competition principles through teaching and public lectures. This collaboration has also enhanced the credibility of competition policy discussion by grounding them in rigorous academic analysis, thereby reinforcing public understanding and acceptance of the need for a strong and adaptive competition law framework. Commissioner Ridho and I previously served as a full-time lecturers at the public universities in Indonesia as well. Our academic background has shaped our perspective on competition policy, combining theoretical foundation with practical and regulatory experience, and have contributed to strong emphasis on evidence-based analysis and policy-oriented enforcement by KPPU. In parallel, KPPU has undertaken a number of internal reform. First, we expanding the interpretation of key legal concepts, such as relevant market and abuse of dominant position, to better capture data-driven and algorithm-based form of dominance. which are increasingly common in digital market. Second, KPPU is strengthening evidentiary standard by recognizing the importance of indirect evidence, including economic data and digital communication. This is essential for addressing competition cases in digital market where traditional forms of evidence are often insufficient. Third, we are addressing institutional and organizational challenges, particularly those related to the secretariat function, staffing, and enforcement mechanism. The objective is to ensure that KPPU, as an independent institution within the executive branch, operates with a clear separation between administrative and functional roles, strengthening accountability and effectiveness. Finally, KPPU is working toward the establishment of provincial representative offices as a part of a broader decentralization effort. This would allow competition law enforcement to become more equitable, responsive, and better aligned with regional economic conditions.
Thank you. Eugenia, when are you expecting the amendment becomes a law? Is it difficult to predict?
Yeah, it's difficult to predict, but we hope that this year it's already done.
Okay, thank you. My next question is about your enforcement. In recent years, KPPU has been very active in enforcing competition law. I would like to ask in particular about the enforcement against cartels and bid rigging. As I understand it, Indonesia does not yet have a leniency program. Well, it's included in the amendment.
Yes.
In the absence of leniency, how has the authority been collecting evidence and building its cases?
KPPU has been able to enforce competition law effectively, including cases involving cartels and bid rigging, despite the absence of formal leniency program, through a combination of complaint-based enforcement and proactive investigations. A significant number of cases originate from reports submitted by the public, particularly by business actors who are competitors and are adversely affected by monopolistic practice or unfair competition. The identity of reporter is kept confidential, except in cases where the reporting party seeks compensation for the damage. In addition to handling complaints, KPPU also initiates cases on its own initiative by conducting preliminary research-based and observable economic phenomena in the market. Before proceeding a formal investigation, KPPU conducts an initial assessment to identify potential anti-competitive conduct using economic analysis. Various methods are employed at this stage, with consumer surveys and focus group discussion being among the most frequently used tools. Surveys are conducted to capture the market behavior and consumer impact, while focus group discussion involve business actors and relevant regulators in the sector concerned to better understand market structure, pricing behavior, and regulatory dynamics. This qualitative and quantitative approach allow KPPU to build a robust factual and economic foundation for its case, even in the absence of leniency mechanism. KPPU has been able to enforce competition law effectively even without a formal leniency program by employing following strategies. First, use of indirect evidence economic analysis. Second, utilization of tender data and bidding patterns. Third, authority to summon and examine relevant parties. Fourth, market structure and incentive-based approach, and use of public complaints and informal whistleblowers. Through its extensive experience in handling cartel and bid rigging cases, KPPU has developed relatively mature methodologies and enforcement practices, despite the absence of formally leniency mechanism. Yeah, I would like to emphasize that the introducing a leniency program under the competition law would be significantly improve KPPU enforcement capacity. I hope that the legislative amendment process can be completed in the near future, even though it is hard to predict, hopefully this year, so that such leniency program can be effectively implemented.
Thank you. My third question is about your regional offices. I've heard that you are planning to expand your regional offices. What challenges have you faced in enforcing competition law at regional level?
Okay. Yeah. Despite the progress and achievement I have outlined, KPPU continues to face a number of structural challenges, particularly in implementing competition law at the regional level. First, regional disparities remain a major issue in Indonesia. KPPU currently operates with only 7 regional offices to cover the entire country. This creates significant constraints in conducting supervision, advocacy, and case handling in a timely and effective manner across diverse regions. Yeah. Sometimes the case I handled is in Kalimantan. It's very far. It's farther than Jakarta to Tokyo, so it's very hard to handle. And in that place, we do not have a regional office. Second, there is uneven understanding and awareness of competition principles among local governments. Yeah. Some regional regulation, although well-intentioned, unintentionally create market barriers to restrict competition, highlighting the need for stronger competition advocacy at a subnational level. Yeah. Third, local policy intervention can sometimes be distortive. Preferential treatment, licensing restriction, or local protection measures may indirectly limit market entry and undermine a level playing field. Fourth, limited access to data and market transparency at the regional level remains a challenge. Yeah. Reliable information on market structure, procurement processes, and businesses actors is often scarce, making early detection of cartel conduct and bid rigging more difficult. Fifth, digital gaps present new enforcement challenges. Traditional asset-based merger thresholds are often insufficient to capture so-called killer acquisitions in digital market, where firms may have limited sales but significant data or innovation value. Finally, legislative limits persist. Indonesia, 25 years old competition law, lacks specific ex-ante tools for digital gatekeepers, and those not yet provide formal leniency protections. which constrain enforcement effectiveness.
So my final question is about your digital enforcement. In recent years, KPPU has been actively enforcing the law in digital cases as well. So in particular, the Google case is one of the KPPU's most high-profile cases, I think. Could you briefly explain the outline of the case and the reaction from business community and the society in general, please?
Okay. Yeah, I will present a brief case on the Google Play billing system case study, which represent a landmark enforcement effort by KPPU in digital economy. The investigation into Google LLC decided under the decision number 3, 2024. Mark of one's KPPU first comprehensive attempts to apply competition principles to global digital platform operating in Indonesia. We have another cases, but the Google case is the first. KPPU found that mandatory use of Google Play billing payment system created significant entry barriers for alternative payment service providers and effectively eliminated consumer choice. By requiring developers to use a single billing system, Google was able to foreclose competition in downstream payment service. For economic perspective, a key element KPPU's reasoning was what we refer to as anti-discount pricing. Google service fee structure ranging from 15 to 30%. 15% for less than $1 million sales, and 30% for over $1 million sales of the developers that sells their product in the Google Play, in the Play Store. Yeah, it increased as developer revenue grew. In competitive market, fees typically decline with a volume due to economies of scale. The opposite pattern observed in this case was therefore treated as a strong indicator of significant monopoly power and abusing the power as well. The impact of its conduct extends beyond individual developers, not only the developers, but it also affected the digital ecosystem and innovation, the viability of digital SMEs, consumer welfare, market structure, and ultimately broader public policy and macroeconomic outcomes. As a result, KPPU imposed a fine. This is the biggest fine for the 24 years of 202.5 billion rupiahs. It's approximately 12 million US dollar. And order Google to allow developers to use alternative billing systems supported by incentive in the form of reduced service fee.
Thank you. What's the status of this case? Has Google appealed to the court?
Yes, it's appeal, and KPPU already won in the first court, and we still waiting for the decision of the Supreme Court.
We don't have much time left, but I'd like to take one question from the floor. Is there anyone?
Hi, Commissioner Eugenia. I was wondering, I mean, we have heard that enforcement against digital giants can be fraught with difficulty, no less political dimension of it. We have had instances of these digital giants threatening to withdraw from a particular market. Meta has threatened to withdraw from Nigeria, not to comply with the news media code in Australia, et cetera, et cetera. And I was wondering if this is a consideration for the KPPU in pursuing this case, and to what extent KPPU is helped by the fact that this issue has arisen in other jurisdictions, and so KPPU is not alone in pursuing this matter against Google.
Okay. KPPU doesn't do not look like it's as a problem. Yeah, because first that even though the fine is the highest fine for KPPU, and I think the fine is smallest among the other fine of the country. So I think it's not a problem. They want to out of the Indonesian market.
Okay. Yeah. So we don't have no time left. So we have no time left. So thank you, Eugenia-san, for your informative and also insightful presentation. And please join me in giving a round of applause to our speaker. Thank you.
I would now like to invite Dr. Bambang Brojonegoro, Dean and Chief Executive Officer of the Asian Development Bank Institute, to deliver the closing remarks. I believe they will bring the podium back onto the stage. Yes.
Very good afternoon, everybody. Mr. Eiji Katani, Chair of Japan Fair Trade Commission, all distinguished chairman, chairperson from Competition Commission across the region, esteemed guests and colleagues, ladies and gentlemen. On behalf of the ADBI, Asian Development Bank Institute, I would like to extend my warmest congratulations to all speakers and participants for your valuable insights and active contribution to today's discussion. Your commitment has been essential to the success of this forum. And also apologize that I just joined this event right at the end because I just arrived from Kuala Lumpur this morning. During the past 2 days, the forum has explored how competition policy is responding to evolving market realities, particularly in the context of digital markets and transition to net zero. In the digital sector, attention focused on how competition authorities are strengthening enforcement through new tools and approaches as digital markets expand rapidly across borders. In the area of sustainability, the dialogue explored how competition policy can support net zero objectives while preventing anti-competitive conduct, including greenwashing and coordination that may undermine competition and innovation. Awareness of these issues is increasingly important, not only for policymakers and regulators, but also for business, consumers, and broader public. This is precisely why platforms like EAC plays an important role in bringing complex competition issues into the public conversation. At ADBI, we have a flagship program titled Shaping Asia's Future Prosperity with Quality Growth that was recently launched last December in Jakarta. This program addresses one of the region's most pressing development questions: how developing economies can transition successfully to high-income status while ensuring growth that is productive, inclusive, and sustainable. For many middle-income economies, the challenge is not a lack of growth ambition, but the difficulty of shifting from factor-driven growth to productivity-driven growth. As wages rise and demographic dividends fade, growth increasingly depends on innovation, firm upgrading, and efficient allocation of resources. Yet, in many cases, markets remain concentrated, entry barriers persist, and competitive pressure is weak. This limit firm dynamism, slows technology adoption, and reduce incentive for innovation, making it harder for economies to move up the value chain. Competition policy plays a critical role in addressing these challenges. By keeping markets contestable, it enables new and more productive firms to enter and scale. By disciplining incumbents, it encourages firms to invest in innovation rather than rely on protected rents. And by safeguarding fair competition, it helps industrial and green policies deliver real outcomes without capture of or inefficiency. In this sense, competition policy is not only an enforcement tool, it is a foundational instrument for productivity growth, economic upgrading, and successful transition to higher income status. In our study, in the flagship study, we tried to learn what Japan and Korea had been doing in the past. Of course, these two economies, these two countries are basically they are the first high-income economies in Asia. And then when we learn about the success story of both countries, it's quite clear competition policy is really an inherent part. You cannot, pursue a very competitive economy if you are not working with the competition policy. That's why even though Japan and Korea, of course, have large conglomerates, large businesses group, but still competition policy is critical and it still encourages small and medium enterprise to be growing in the middle of the competition with, of course, the medium and upper scale of business. So this is really a good experience that Japan and Korea can also share their experience with other Asian economies. Today, escaping the middle income trap is more difficult than before. Policymakers must now navigate digital platform concentration, increasingly cross-border markets, and climate transition challenges all at the same time. Yet, these challenges also create new opportunities. Climate and energy transition can offer middle-income economies pathways to absorb global technologies, build domestic capabilities, and become producers of green intermediaries for global markets. Strong competition policy helps ensure that digital and green transition are not dominated by a few incumbents, and that innovation and technology diffuse across the economy. However, in many middle-income economies, resources such as credit, land, talent, and public contracts remain concentrated among connected incumbents rather than flowing for the most productive firms. Competition policy can help lower entry barriers, prevent abuses of dominance, and deter collusion, allowing productive firms to grow while unproductive rents shrink. So when I arrived in this room, Jenny, who is now the Indonesian Commissioner for Competition Policy, just presented about the Google case. So I remember that case very well because at that time I was still in Indonesia as a professor of economics. And I remember they are trying also to approach me to be like, what is it, the witness or the expert witness for this case. But at that time, after trying to understand what they are going to contest again Indonesian Commission policy, I decided I don't think it will be good for me to be involved. I mean, first, because I think exactly like the question coming from the audience is highly politically sensitive. And of course, dealing with the big or giant tech is not always easy because they are the giant, and I don't think we are in that kind of position. And secondly, if I really take that case, then it means I have to face her. And Jenny used to be my student, so I don't want to really fight with my student, even though we might have different opinion, but I don't think it's good if one of your best student has to argue publicly with yourself. So I decided not really interested to be part of the case. So in this context, I'm pleased to share with you that in 2024, ADBI, ADB, and the JFTC jointly launched a book on designing competition policy for economic development in Asia and Pacific, which shows that governance quality and effective enforcement matters, as stronger competition policy is consistently associated with more competitive local markets, highlighting the importance of moving beyond law adoption to implementation. Going forward, we will build on this collaboration to examine more specifically how competition policies can help middle-income economies enhance productivity, strengthen innovation, and progress toward higher income status. By bringing voices together across institutions, economies, and disciplines, forums like this help shaping the future of inclusive and sustainable growth in the region. Once again, congratulations to all of you for your outstanding efforts, and thank you for contributing to the success of this year's forum. I wish you all a safe and pleasant journey home. Thank you very much.
Thank you very much, Dr. Brojonegoro. And this brings proceedings at the 17th East Asia Conference on Competition Law and Policy to a close. But before we officially disband, there are two more things to do. The first one, I believe, is that the organizers would like us to fill out a survey for the event. I've been told it is very important to them, so please do that. Take a moment and do it. Thank you very much. And the second item is we need to take a photo with a few of the guests of the conference. And of course, this being an event in Asia, the activity did not take place with no proof of photos. So obviously, we need to do that. So I'd like to now invite Chairman Chatani to come on stage, Commissioner Aoki, and Professor Joseph Choi, Director General Sun, Director General Sakuma, Dr. Alhan Kayala, Professor Wakui, and Professor Wakayabashi, and Dr. Eugenia, and Dr. Brojonegoro. Yes, thank you.